Oh yay, oh yay, oh yay. The Court of Appeals for the 15th Judicial District is now open.
Subject to adjourn. Thank you. Please be seated. You'll have to excuse us. Normally, we have the obligatory prayer we say before we begin, but we're not used to a crowd this size, so perhaps our judges and clerks have a little bit of stage fright, but we appreciate having all of you here. We just have one case on the docket, which we'll proceed to shortly. Thereafter, we'll take a brief break, and then any of you that want to stay around and ask questions about the courts, civil justice system in Texas, or how you can become a judge too, or a famous attorney like these folks up front, please, you're welcome to hang around, and we'll take question and answers for a while. Only case on our docket this morning is State of Texas versus Johnson & Johnson et al. Who's present arguing for the appellant?
John Maslin for the state of Texas.
Reserving time for rebuttal.
Yes, Your Honor, 5 minutes.
Thank you. And appellees?
Aaron Nielsen for the appellees, Your Honor.
All right, you may proceed when ready.
Chief Justice Brister, and may it please the court. When a company serves a market in a state, it can reasonably anticipate facing state friend agree and miswords below a full roadmap Texas's consumer protection laws with impunity, so long as it does not draft its misrepresentations here.
What evidence do we have in the record that the parent companies are operating in the state of Texas?
They don't necessarily need to operate in the state of Texas, Your Honor. They need to have sufficient contacts with the state of Texas. And the allegations in the complaint show that they have those sufficient contacts to, they've purposely availed themselves of the protections and benefits of Texas law.
So today, with our plea to the jurisdiction framework, you have pleadings, and then if the defendants come and rebut those pleadings with evidence, then you're kind of switch from one playing field, the pleadings playing field, to the evidence playing field. Which playing field are we on for purposes of this appeal?
I think you're on both playing fields, respectfully, Your Honor. I think what this court said in Meadow was that you look at the pleadings, and that's the baseline. However, you're also allowed to go beyond the pleadings to look at affidavits, which both parties offered here in this case. You're allowed to look at live testimony. Neither party offered live testimony at the special appearance hearing. And you're also allowed to look at documentary evidence. So you can look at both the pleadings and the evidence that was presented in the district court to decide whether there is personal jurisdiction over Johnson & Johnson and Ken Buell.
So specifically, it's not enough to say, the defendants all did, the defendants, as you do frequently in the pleading, the defendants marketed, sold, et cetera, Tylenol forever and ever. But you got to do it as to each party. You can't just say the defendants generally. Supreme Court said that several times, Kelly versus General Interior, Siskin versus Philip Foundation for Education. That's been the law for 40 or 50 years at least. You got to say specifically. And so I looked through your petition, and you got a lot of stuff. I can tell you're angry at them. The reckoning has arrived. Tens of billions of dollars in damages to permanently injured children. Defendants willfully ignored and attempted to silence the science. Defendants have shunned this duty to warn and willfully ignored the science. So I got it. You're angry at them. But what I need to know is, what did the parent do that targeted Texas? And then next, what did the former parent, Johnson & Johnson, do? What did they do? And defendants is not good enough because you can't just lump them all together.
Sure, I'll start with Johnson and Johnson, Your Honor. I think that one's actually the easier of the two. For purposes of purposeful availment, the Fifth Circuit has already said that Johnson and Johnson has purposefully availed itself of the protections of Texas law. That's Dupuy Orthopedics.
But we
So
don't.
I forget, does the Fifth Circuit tell us what to do?
It does not, Your Honor. But I think that that is a very persuasive decision that says they have purposefully availed. Now, obviously, purposeful availment is not enough. You also need to have relatedness. And if you look at our
Yeah, but
petition,
You got to have purposely availed. It's not enough to tell me somebody else thought they purposely availed. I want to know what you pleaded because I'm having trouble finding it. And specifically in your pleadings, you spend a lot of time, you start off on page 13 saying Johnson & Johnson manufactures, sells Tylenols, has control over the product, distribution, et cetera, et cetera. And then you proceed to list all the subs since 1970 who actually designed, manufactured, packaged, labeled, and sold. So now I'm not asking
Yep.
about all the subs. I'm asking about Johnson & Johnson, the parent. What did they do when you yourself had pled for 50 years? It was somebody else.
okay, so if you look at page 33 of the joint appendix, that's tab C in your bench books, there you will have the allegation that Johnson & Johnson issued a statement to Reuters about Johnson & Johnson's belief on the safety of Tylenol. If you look at page 39, you have an email from the head of epidemiology at Johnson & Johnson to Jesse Berlin, who's also at Johnson & Johnson, where they say that the weight of the evidence linking Tylenol to the various neurodevelopmental disorder is starting to get heavy.
So
How
you've
does-
got 20 pages of experts, including the Norway family and something or other study, that say, no, it is dangerous. So are those all contacts with Texas? Can we sue the Norway experts here because they once said that
No.
acetaminophen is not safe?
When we get to relatedness, I think that what you have is that millions of bottles of Tylenol were sold here in the state of Texas.
But not by Johnson & Johnson, the parent company.
We believe that Johnson & Johnson did sell it between 1973 and the time that Kenvue took over, but they don't need to.
So between 1973 and when? Because I didn't see this in your petition.
Wasn't that J&J Consumer Inc.?
J&J Consumer Inc. was part of it, but we allege that Johnson & Johnson controlled the marketing and the safety statements that were made.
By
if-
what? What did they do and where did they do it?
Okay, so they controlled the.
What did they do? I mean, they owned, if it's wholly owned, they own all the stock.
Mhm.
But owning stock in Texas company is not a minimum contact. It may be as to, something that you do wrong with that stock, but just being a parent company is not.
They told Johnson & Johnson Consumer Inc., they told Kenvue what messaging needed to be done. And under CIRC, that's sufficient when there is that type of entanglement between a parent and a sub.
Is there evidence of that in the record?
I think that we have pled and we have also had sworn affidavits, both from an investigator with the Office of the Attorney General and then a sworn declaration by Mr. Stone. Those are exhibits 2 and 4 in your bench books that show that all of the allegations that we make in the original petition are true and correct. And that is the same type of evidence, affidavits, that the defendants have also presented in this case, where they have said, oh, we don't sell this, we're not involved with it. But it cannot be the case
Well,
that. a
wait,
def-
wait, you're saying a verified pleading is the same as an affidavit that spells out specific facts?
When the affidavit, for example, of the investigator from the Office of the Attorney General, says that each fact that is pled or made in a motion or in a pleading, the affidavit from the Office of the Attorney General investigator was on the temporary restraining order, which was before the court at the time of the special appearance. That is showing that each fact pled in that is true and correct.
How does that work if you have a pleading, like one of the allegations against Johnson and Johnson as an entity was upon information and belief, but then you have an affidavit verifying the petition, how do those two things go together? Because you can't really have a affidavit on information and belief.
I think two things, Your Honor. Number one is that even if you ignore everything that's on information and belief and just look at the allegations and the complaint that are not on information and belief, and in the motion for a temporary restraining order, those contacts alone are sufficient. And otherwise, I think you just look at, the allegations that are not on information and belief.
And can you also address the Tufta theory for jurisdiction here as well?
Sure.
And yeah, and when you're doing that, is it dependent on the finding that there's personal jurisdiction over the DTPA claim when you're doing that? Did you address
Yes.
that?
We concede that we need to show that there is personal jurisdiction over the DTPA claim in order for there to be jurisdiction over the Tufta claims. And I would point the court to three particular cases for why there's jurisdiction under the Tufta claims. First, you have Amoco from the Southern District of Texas and Dantos from the Fifth Circuit that essentially say that when you have a
So,
Tufta,
the great thing about being a brand new court is none of those are binding on us. In fact, almost nothing except Texas Supreme Court cases are binding on us. So the Texas Supreme Court is our North Star. Have you got anything
Ratamco from the
What's
Texas,
that?
Ratamco. And just
Yeah.
the site on that is 270.
But that was a case where there was a fraudulent conveyance of property in Texas, right?
It was an interest of property in Texas to a foreign
So
corporation.
yeah, you want to, monkey around with Texas real estate, that's going to be a minimum contact. But we don't have anything that Johnson and Johnson or the Kenvue parent company was mucking around with real estate in Texas. So you say they're monkeying around with the warnings, and I'm not sure that doing research and development outside of Texas counts as a Texas contact until you place something in the stream of commerce, which you concede they didn't do.
We do not concede that they did not place things in the stream of commerce, but they've also placed advertisements. If you go into any drugstore or grocery store, you see advertisements for Tylenol. Every bottle that was sold.
And we can assume that was paid for, contracted or whatever by Johnson, by the former owners of Tylenol and not the current distributor.
We're saying that there was such entanglement between, and that Johnson & Johnson and Kenvue Inc. directed both Johnson & Johnson Consumer Inc. and Kenvue Brands to engage in that conduct.
Well, ordinarily, don't we have to go through specific factors in order to pierce the corporate veil and find that one company is responsible for the actions of another? And if so, is that what you're asking us to do here?
We're not asking you to do that. And that's not what happened in Searcy either, which is from the Texas Supreme Court. There, the Texas Supreme Court said that they found no personal jurisdiction over the Canadian company because there were no minimum contacts, but they found personal jurisdiction over the Bermudan company. And the reason that they found personal jurisdiction over the Bermudan company is because there was sufficient entanglement between the Bermuda one level up company and one level down in order to say that they purposefully availed themselves of the protections of Texas law, and that the conduct complained of was related to the claims that were being asserted in that case. And so that's why the Texas Supreme Court and Justice Willett said that we are going to, I don't want to say split the baby, but like split the claims here and say that the claims against the Canadian corporation, we don't have jurisdiction over, but the court does have jurisdiction over the claims against the Bermudan company. So you don't necessarily need to pierce the corporate veil. All you need to show is that the corporate company is entangled and is playing a role in the activities of here Kenvue Brands Inc. and of the Johnson & Johnson Consumer Inc. And we've pled that. We've pled that, you know, Johnson & Johnson is the one that issued the statement to Reuters that said that our Tylenol is safe. It did not say Kenvue Brands Tylenol is safe.
Well,
And
we don't count on press releases for being the facts. I mean, there's a lot of people that say, let me introduce you to my partner, when they're not partners at all. I mean, there's specific cases saying calling somebody your partner does not make a partnership. So, you know, Tylenol certainly is, you know, once was, but apparently it's not now. And if this is a stream of commerce case, you know, the stream of commerce from when they were owner, that stream's gone out to sea. I mean, they're not still putting these products in the stream of commerce except under your entanglement theory.
yes, and again, we are asserting claims back to 1973. Kenvue Inc. and Kenvue Brands Inc. were not created until just a few years ago. And Johnson & Johnson Consumer, as Justice Field said, was before that. But we also have, for example, the emails from Rachel Weinstein to Jesse Berlin. That's page 39 of the joint appendix that shows that Johnson & Johnson was the one that was making the decisions here.
Thank you, Mr. Masson.
Thank you, Your Honor.
Mr. Nielsen.
May it please the court. The medical consensus supports the safety of Tylenol. The state is free to bring meritless claims, and that litigation is happening right now in Panola County. What the state is not free to do is sue the wrong defendant. And the reason we are here is because the state is not satisfied just suing Kenvue Brands, the operating entity that sells in Texas. It wants to also sue two out-of-state holding companies that don't sell Tylenol anywhere. And this is not just my opinion. I think so to your point, Justice Ferris. We offered evidence in the district court on both of those points. They're holding companies that don't do business in Texas. And the state had an opportunity to come back and offer evidence. It didn't. It offered zero evidence. It says instead to the court, you have to accept our pleadings. Well, that might be the law in states not Texas, but in Texas, the procedure is you offer evidence, you get your chance, and if there's no evidence, there's no evidence, and the party that offer evidence is going to win. That is where we are. So the district court found implied findings that the two parent companies do not do business in Texas. Kenvue Brands does do business in Texas, so the state can sue Kenvue Brands, and we have discovery happening right now in that litigation in Panola County.
So now they filed a special appearance too, right?
They did as to Tufta. As to the Tufta claim, which we're going to talk about.
Okay.
As to Tufta, none of the defendants are subject to personal jurisdiction. But as for the DTPA, Kenvue Brands is subject to jurisdiction in Texas because they sell Tylenol in Texas. And that litigation, the state can make all their theories that they want to. There will be discovery. There will be a case about that. The question here is the parents.
The comments from opposing counsel made me think of a question I don't want to answer to, which is, does J&J Consumer Inc. still exist? And if so, are they a defendant in the case?
I do not know if they still exist. They are not a defendant. I believe they do exist, but I don't know that for sure. They're not a defendant in this case. And I want to make a couple of points. Today they said, well, look at Exhibit 2 and 4 of their bench book, which we have sworn affidavits too. That's what they say. Well, okay, that doesn't matter because even if that were so, again, this wasn't the argument that they made below. I'm going to quote what this court said last year in Meta. If the parties present conflicting evidence, we will resolve the dispute by upholding the trial court's determination, period. That is quoting the Texas Supreme Court TV Azteca case. So under the best view of their argument, that is where we are. We have evidence. If we're going to count their affidavits of verified, which again, I think there's real problems with that, Justice Field, but assuming spot them that, we end up in Meta, and Meta says we're going to uphold the trial court. So that's where we are on that. They also mentioned today the Depew case from the Fifth Circuit. You are right, that is not binding on this court. It's also completely irrelevant. There's two reasons why. There's a really easy reason and one that takes a little bit more time to unpack. I will give you the very easy reason first. The very easy reason is we're talking about specific jurisdiction. This case is about Tylenol. That case was about hip transplants. There's no relatedness between the two cases. So even if somehow the Fifth Circuit precedent mattered, which it doesn't, it's completely irrelevant because we're talking about specific jurisdiction. There's a more technical reason why it's irrelevant as well, and that is a stream of commerce case. They do not plead a stream of commerce case in their petition. And this court said last year in Yelp, if it's not in the petition, it's not live on appeal, it's gone. So they don't have a stream of commerce theory. But even if they did, it would be borderline frivolous under Texas law. And the reason why is we have to go back to Civil Procedure 101. The stream of commerce case from the US Supreme Court, the canonical case, is Asahi Metal from 1987. And if you remember in Asahi, the court divided. You had the Brennan wing of the court and the O'Connor wing of the court. The Brennan wing of the court, neither side had a majority, so you had two pluralities. The Brennan wing of the court says essentially, but for causation. If you put it in the stream of commerce, wherever it ends up, personal jurisdiction. And O'Connor says, no, 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 no. That would eviscerate personal jurisdiction. You have to target. The reason this matters is because the Fifth Circuit, as it says in Depew, we follow Brennan. That is not the law of Texas. In Texas, we follow the law of O'Connor. I would point the court to Michiana, written by Chief Justice Brister, where he says that, but there's a whole slew of other.
Great case.
It's a great case. It's exactly on point here. There's a whole slew of others where Texas is stream of commerce plus.
But
Right.
what do we do with to me, if I'm interpreting your opposing counsel's arguments correctly, that there's perhaps another law or another way to get there by press release?
Yeah.
Is that,
So let's talk about
Okay.
that. Let's go. I think it's important to go through all three of the defendants. So J&J, let's start with J&J. Again, we have evidence that that J&J does not do business in Texas. They have allegations. That by itself, we're done. But let's assume that their allegations somehow were correct. So what do they point to? They point to a press release, which I don't think it was a press release. It was a statement they allege to a Reuters reporter about a study in Norway in 2013. And they say that was J&J. Okay, well, there's some problems with that. First of all, J&J does not sell the product. So the nexus is not very tight to begin with.
And before you continue, has it ever sold the product from 1973 to present?
No, Your Honor. We have evidence, as far as I know, we have sworn evidence that we have not. Even their own petition goes up to 1970, and then they have a whole string of subsidiaries. So we're talking about 1970. The DTPA didn't come into effect until 1973. So under their own theory, that doesn't work. So to go back to the press release, it's about a product you don't sell in a response to a study from Norway in 2013. Last year in Meta, this court said that even the CEO of a drug company who makes phone calls to physicians in Texas, that is too attenuated. We are orders of magnitude away from that, and that's what they're relying on. They also say, well, what about 2018? I'm quoting now from their brief. This is page 26. A J&J affiliated employee was started to feel heavy about this. Okay, well, I'm going to look at their citation, which they tell us to do. Look at their page. That's JA 39. It doesn't say one word about Texas on JA 39. So what you have is an internal statement alleged. Again, we have evidence. They have allegations. An alleged internal statement, not in Texas, that is anything about Texas. Well, that is squarely precluded by Meta. Meta says, and again, I'm going to try to get the quote right from the podium here. Drug manufacturing decisions made outside of Texas are not contacts with Texas. We don't even have that. We have a company that does not manufacture the product, makes an internal statement outside of Texas. Again, that is squarely precluded by this court's decision.
Give me to shift focus a little bit.
Sure.
Tell me what's going on in Bailey County.
Yeah, I will tell you what's going on in Bailey County. So after we prevailed on the special appearance in Panola County, the state filed an ex parte TRO in Bailey County without telling the Bailey County Court that they had just lost in Panola County, saying, well, that these parent companies and Kenvue Brands has to register in Texas.
Against all of the same five
Yes.
parties?
Yes, Your Honor. And the court gave them a partial TRO. We then find out about it. Again, we represent them. They know we're in litigation. They do not give us notice of this. We find out about it. We rush to Bailey County to explain to
Which
the.
is not easy to
Not easy to
do.
do.
No,
Since
That-
mule shoe is not on the way anywhere.
that is certainly true, Your Honor. We rushed there and we explained to the court that, no, Your Honor, this is not true. We told them the backstory. The judge had a hearing. This was a telephonic hearing, and the judge vacates the TRO. They then take that vacated TRO and go back to Panola County and say, Your Honor, you have to have personal jurisdiction over them because we have a TRO. And they don't tell the court in Panola County that that TRO had been vacated. I've never seen this in my career, respectfully, Your Honor.
So but the Bailey County case is abated, as I understand
It
it?
is stayed pending this court's decision. They have dropped their claim against Kenvue Brands in Bailey County because Kenvue Brands is registered in Texas. It's only now against the two parents. We've said, as to both of them, for the same reason as in Panola County, there is no personal jurisdiction in Texas. They disagree. That court is waiting to decide what this court does, as whether there's going to be personal jurisdiction against the parents in Bailey County as well. There's also the separate litigation happening in Travis County about the CIDs. So after we prevailed in Panola County, immediately there was a flurry of CIDs in response about unrelated products. J&J went to the Travis County Court and said, this is retaliation. Like, we prevailed and now they're punishing us for this. And they answered that, and they did not deny that it was retaliation. That right now has not been moved for a setting, so that's still pending. But the argument that we have there as well is there's no personal jurisdiction, as the court found in Panola County.
Mr. Nielsen, bear with me. It's going to take a little wind up to get to the question, but looking at the Supreme Court's precedent on our review of a special appearance, it looks like you're absolutely right. The Kelly case and TVS Tech spell it out. If you have pleadings and then an affidavit denying those pleadings, no findings of fact, you imply the findings and you affirm on that issue. Is there a scenario still, and this is the part I'm fuzzy on the Supreme Court's writings, where if the affidavit filed by the defendant isn't broad enough to meet all of the allegations in the petition, that you could still have a question for the court to decide as a matter of law whether the petition itself alleges enough facts to get there?
Yeah, so
I hope that's clear,
No,
more
Your-
clear than mud.
Your Honor, I understand the question because I also have been reading those cases pretty closely. I think conceptually, there's some language which I quoted earlier, which this court quoted in Meta, which says if both sides offer evidence, we're just done. But what do you do if there's a gap in the evidence?
Right.
Here, thankfully, the court doesn't need to get into that.
That was going to be my next question. You anticipated it.
It does not need to get, and we know, and this is how we know that. Because the state pleads that all the defendants are the same. Again, they clump all the defendants together. We offer evidence that the parents are not the same because they don't do business in Texas. So the test from BMC software is it necessary to support the judgment? Well, here we know for a fact what is necessary to support the judgment because there's this one over here. There is personal jurisdiction. There is these two over here, no personal jurisdiction. The only difference between the two is these ones, there's affidavits that they don't do business in Texas or other sorts of evidence. So we know the court necessarily found that they do not do business in Texas, which I think is going to be sufficient. If I would, again, I'm happy to answer questions. I would like to say a word about Kenvue Inc. Because here, I think there are arguments about J&J. They're not based in the record, but at least they have record sites. Look at page 26 and 27 of their brief about Kenvue Inc. They have 3 things about Kenvue Inc. And you will notice there is not a single record site for any of them. Why? Because all of those are outside of the record. So that's a huge problem for them for 2 reasons. One, there's the general rule, which is going to apply to every appellate court in Texas. you are bound by the record on appeal, and you can't start reversing based on things not in the record. But there is a special rule for personal jurisdiction that this court explained in Yelp, which is it has to be in the petition. Well, what do they have? They have a press release where they talk about, where Kenvue Inc. talks about our iconic brands. That is after the petition. This is the press release announcing the proposed merger between Kenvue Inc. and Kimberly-Clark. That is after the petition. They did not move to amend the petition. They didn't add it to the case. It's just not there. So it's not in the record of appeal, and it's not in the petition. But here's the thing, even if we're gonna go outside of the record, look at it. It's, all it is an announcement that there's going to be a future merger between two companies. There is not one statement in there about Tylenol is safe for pregnant mothers. It's not advertisement. It is a statement of a corporate transaction that's going to happen. That's just it's not nearly close to being enough.
So at the time of the spinoff, had they already filed suit claiming Tylenol was dangerous for pregnant women?
The state certainly hadn't. So the story, as I understand it, was in 2021, J&J announced there's going to be a spinoff. In 2022, you get the first of the cases filed against Tylenol. And then you have the spinoff, I think 2023 or 2024 is when the actual spinoff, 2023, and then 2024 is when J&J gets rid of all of its shares. So this is a process before. It's also, by the way, other drug companies were doing the same thing at the same time. But it's not connected to Texas, regardless, is the part that I want to make here for their Tufta theory, which I heard them just say that if they don't have a DTPA theory against the two parents, they do not have a Tufta theory either. So the only Tufta case we have to talk about is Kenvue Brands. But here's the thing about Kenvue Brands. I've been trying to prepare for this argument, and I do, for the life of me, do not understand what their Tufta theory against Kenvue Brands is. Look at page 1 of their brief to this court, where they explain their Tufta theory. Their Tufta theory was J&J spun off Kenvue Inc. to avoid liability to Texas. What does Kenvue Brands have to do with that? Kenvue Brands didn't spin anything off. Kenvue Brands was the subsidiary of the company that was spun off. So you go back through and look at their petition to find allegations about Kenvue Brands with respect to Tufta, and you're not going to find them, respectfully. They're just not there. But even if I'm wrong about that, their argument runs into two black letter Texas law. One is the directed tort theory. You can't face personal jurisdiction by alleging a tort. So the theory is you have evaded liability. That's the tort, so we're going to go after you. Well, that's exactly the merits of the tort. That is exactly the allegations of the tort. That's Michiana, an excellent case, says you can't do that. That's also Old Republic. You just can't do that. But if I'm wrong about that too, which I'm not wrong about that, one more problem for them. And this is the objective facts test. And this goes back to Moki Mock, which is another classic Texas Supreme Court case. But the idea is, where are the objective facts? For it to be substantially connected to Texas, the objective facts have to be in Texas. Where are the objective facts of a transaction from New Jersey and Delaware? They're not in Texas. So when we wrote our brief, I thought that was a killer point. I really thought that's it. I don't know what they're going to say to that, because it's Texas precedent. It's right on. The court reiterated the objective facts test last year in Meta. So I said, okay, well, what are they going to do? So they filed a reply brief, and I started looking through the reply brief to try to find the answer to objective facts. And they have no answer to objective facts. The words objective facts are nowhere found in the reply brief because it was a killer point and they just ignored it. So that argument fails for Kenvue Brands, but also fails for all three of the parents on their Tufta theory, kind of like their bank shot idea, that if you plead one thing, then they become a debtor, and then you can plead and stop any transaction anywhere in the country, which is a principle that really would have no limit. If you could do that, any state could sue to block any transaction in any other state. This court would be breaking new grounds on that.
I am a little troubled. I understand the different corporations, but you know, if you have a company like Johnson and Johnson, that's, you know, the name's been affiliated with Tylenol, even if they don't own it and distribute it, and they're saying it's all safe, and people rely on, you know, household name Johnson and Johnson. I'm a little troubled that there's nothing that they're responsible for. And then why doesn't Kenvue Brands just have Johnson & Johnson do all the press releases of how Tylenol's safe and you don't need to worry anything, and these are a bunch of plaintiffs' attorneys, et cetera, et cetera. I mean, at what point is there some duty to keep your mouth shut if it's not your product?
Yeah, I hear that, Your Honor. Thankfully, again, that's not the facts of this case. And the answer to that would be two things. One, if they actually are doing business in Texas, then you could get them. But two, you could do an alter ego theory. So it really is, if, say, for instance, you had a scheme where you had some other entity making all of your
You take all
statements.
the liabilities, we'll make all the statements.
Correct. Then you start to have that's what alter ego or jurisdictional veil piercing would be for. But they have told this court today, but also in their brief, that is not their theory. It's also nowhere found in their petition. So it'd be way too late in the game for them to bring that up now, again, per this court's decision in Yelp.
And do you agree with the statement that the case law suggests you don't have to go down the alter ego trail if there's just interference of some sort?
I mean, I don't understand how that theory could possibly work here. I mean, if you have sufficient context of your own that you could be making statements that would count as somehow advertising or something, then maybe. But again, we don't have that. The only thing that they point to is a 2013 statement alleged, again, we have evidence, they have allegations, alleged about a study from Norway. That is not advertising in Texas under any plausible interpretation of the concept. They just don't have the evidence. And that's my last point, if I may. We have evidence, they don't. The court should side with the party with evidence and not the party without. We ask the court to affirm.
Thank you, Mr. Nielsen. Mr. Maslach.
Thank you, Your Honor. I'd like to start with Justice Fields' question about the scope of affidavits. I think that what Mr. Nielsen said about BMC is very critical here. What BMC said, what the Texas Supreme Court said, is that an implied finding is only those findings that are, quote, necessary for the district court's decision. You typically find plaintiffs making this argument after a special appearance is denied. The reason that plaintiffs are typically the ones that are making this argument is because if a district court denies a special appearance, that means that it necessarily found both that there was purposeful availment and that there was relatedness. That's not the case when the district court grants a special appearance, because there, the district court could have found that there was no purposeful availment, or it could have found that there was no relatedness.
Well,
or,
I disagree with that. I mean, the reason we imply all findings in favor of a jury, as I also wrote in 2007 for the Supreme Court, is not because we think jurors find everything in favor of whoever wins the case. It's because appellate judges don't get to decide those matters. And if we pick and choose, well, maybe the jury did this and this, but you know, we think they should have done that. That's not our job. It's just we assume, if it's contested, that the trial judge makes this call. We're not making this call. And for us to butt in and say, well, we think the judge decided it not on relatedness and not on contacts, we're taking over the judge's job. That's not what the implied finding is for. The implied finding is to keep appellate courts separate from trial courts, not because it's a prediction of what the trial judge actually did, right?
Respectfully, Your Honor, I disagree. I think that what the case law says is that this court's review of an order granting or denying a special appearance is de novo, and that sometimes that involves a factual finding. And when it does involve a factual finding, then, or an implicit factual finding, you know, then we can challenge the factual sufficiency of that decision or the legal sufficiency. That's much different than looking.
We don't defer on legal sufficiency. I agree with you.
And I don't think that you defer on factual sufficiency either when a district court could have made either decision.
Could
where
you also speak briefly to your opposing counsel's argument about Yelp, that there's just simply not enough in the state's petition and that you can't go outside the petition to come up with essentially new hooks for jurisdiction? Can you win under Yelp? Are you asking for a change of the law with respect to the holding from Yelp, or what is the state's position on that?
Our position is that this case is much easier than Yelp. In Yelp, there was no quote sales of anything that were happening here in Texas. There was nothing that actually happened here in Texas with respect to advertising. That is
There were
what,
crisis pregnancy centers in Texas where Yelp was adding a warning on them that they didn't want. What could be more targeted to Texas than that?
those warnings were being added in California. Here you have.
To websites for entities in Texas.
Correct. The websites were entities in Texas, and people from around the country could access those websites. Here, to access the advertisements that were being made in Texas, you had to be here in Texas. You had to go to the CVS or the Walgreens to see the advertisements that were here in Texas. And then lastly, I would like to address the evidence part, where Mr. Nielsen comes up here and says, look, there's no evidence here. We tried to present evidence. That's Exhibit 5 in your bench book. Exhibit 6 is them saying, no, you can't go get evidence. You can't present evidence here. And when we tried to go get evidence, and we went to the district court in Panola County and said, we have evidence we would like to present on these special appearances. They went to the Southern District of New York to Judge Coate, and they sought to sanction Keller Postman and Ashley Keller, and said that you should sanction them for trying to present evidence that shows that there is personal jurisdiction over these defendants in Panola County. You should not allow them to go and seek sanctions and bar us from presenting evidence and then rely upon the lack of that evidence to affirm the district court's decision. Therefore, this
While I've
court.
got you, Mr. Maslin, let me give you a couple extra minutes. I'm concerned about this case. Part of what this court was created to do was to make sure that things that affect everybody in Texas, and whether Tylenol gets banned or gets a warning that pregnant women stop taking it, is a big deal. And as you allege in your petitions, tens of billions of dollars involved. Why, if that's the issue, would you file that case in Panola County, where the Carthage is 6,000 people? You drive 20 minutes and you got to speak Cajun because you're in Louisiana. On the other hand, and then you file in Bailey County, exactly the same thing, a tiny county with Muleshoe is the county seat. You drive 20 miles west and you're in New Mexico. Why is it that your client, may not have been your call, but your client insists on filing one of the biggest cases in Texas in two of the most remote, most rural, and most not known for, maybe fine county, but maybe great jurors. And but this just looks like what happened for 100 years in the South, where civil justice system was used to abuse people, basically big companies, by home cooking. Explain to me how you picked these two remote counties for this huge case.
Two answers to that, Your Honor. First, I think that the fact that this court exists and was created shows that that can no longer happen in Texas. Whether we file it in Bailey County, in Travis County, in Harris County, in Panola County, we know where that appeal is
You got to
going.
come to us.
We're coming to you no matter what, whether we win it, whether they win it, it's coming to you. And then, probably eventually it's going to the Texas Supreme Court. Like, that's going to be the order. So it really, it does matter in so much as that is where we are starting. But to say that, we're trying to, for example, file a case in Texas Federal District Court because we really want to be before the Fifth Circuit, or we're filing in the District of Massachusetts because we really want to be in the First Circuit. That's not what's happening here. We always know that we're going to come to the 15th Court of Appeals on any appellate issues. And the text of the DTPA is clear with respect to venue. It can happen where any misrepresentation occurred. Here, there was a misrepresentation both in Bailey County and in Panola County regarding the safety of Tylenol. And therefore, my client decided that those were appropriate venues for this, and there was no real challenge to venue on that basis because you can pursue those claims anywhere there is a violation.
The law is one thing. The appearance of doing justice, which applies to all of us in government service, including the Attorney General's office. It's one of the best law firms, biggest law firms in Texas, the Office of Attorney General. And it just troubles me that the biggest cases would get filed in the most remote places. And I'm sure great jurors there, but these are very rural, rustic counties. And it just doesn't, I'm just wondering if that's something that you would address with your clients.
I could certainly address it with my clients, but
That's all I'm asking. This
But-
just doesn't look great.
for that, respectfully, Your Honor, I think that saying that every big case in a state must be, filed in Travis County or
No, that's
filed.
the opposite. We were, the business courts were created to fix some of that, but it's just, there isn't the appearance of, as back when I started out, Joe Jamel, I wanted to file my case at a place where I get a jury I like the look of. And that's the kind of thing that we're also trying to attract major businesses to Texas. We've got a lot of people moving here. We've got a booming economy. And if the deal is, if you get crosswise with the Attorney General's office, you're going to find yourself in some remote place fighting a case worth tens of billions of dollars. I'm not sure that is a wise thing to do, but that may be more of a legislative call, but I'm just puzzled if there may be something about Panola County that I don't know, but it's just, it is trouble.
It's a beautiful county.
I'm sure it is. I'm sure it is. All right. Thank you very much.
Thank
Case
you,
will be
Your Honor.
submitted. Marshal adjourn the court.
All rise.
Michael.
Oh, yay. Yes.
This Honorable Court of Appeals for 15th Circuit now stands adjourned.
Oh, yay, oh, yay, oh, yay. The Honorable Court for the 15th Judicial District now stands adjourned.